now in session.
Please be seated. Good morning. We are here for oral argument in case number CR18-0308, State v. Thornton. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal. If you decide to reserve time, however, please keep track of it yourself using the clock at the podium. These proceedings are being audio and video recorded, so we would be grateful if, when you approach the podium, you would identify yourself and your client at the beginning of your argument. We have read the briefs, discussed the case at conference, and are familiar with the arguments raised. Counsel, please keep that in mind as you make your arguments. So with that, you may proceed.
Thank you, Your Honor. May it please the court, my name is Brian Strong. I represent James Thornton, who is not present today. However, his wife, Mimi, and several family members are sitting behind me to my left. And, Your Honors, I do hope to reserve about 10 minutes of my allotted time for rebuttal. Your Honors, helping a family member obtain a business opportunity is not illegal. By encouraging Mr. Colson to accept the offer from JK Shares, all Mr. Thornton did was provide JK Shares an opportunity to purchase, renovate, and resell a home in the hopes of making money. Neither the family relationship nor the profit motive were illegal. The Hawes and Proctor cases direct this court to consider two key issues. Number one, did Mr. Thornton ever paint a false picture for Bayview, the senior lien holder? Or number two, did Mr. Thornton ever change the nature of the transaction? Mr. Thornton did neither of those items. Mr. Thornton did nothing to get Bayview to detrimentally change its financial position in any way.
Why would we not say that he, by leaving out information to Bayview, why is that not conduct that would show that there was a fraudulent misrepresentation or fraudulent activity?
To begin with, the statute 13-201 says you can only consider an omission if there is a affirmative duty in the statute to do something, and here there is no statute or Arizona Administrative Code anywhere that says the real estate agent for the owner has a duty to disclose other offers to a lien holder. That's the first.
But how about misrepresenting the quality of the property? Misrepresenting that it's in disrepair, or that, and when there's actually been fixtures that have been removed that will be immediately reinstalled, that a pool pump has been taken that can easily be reinstalled. Why wouldn't that be a material omission or misrepresentation?
And if I may, I think I need to answer that in two parts, Your Honor. To begin with, there was never any proof that fixtures were removed. The only way we can know if something is a fixture is if the contract between the parties, the actual deed of trust, was entered into evidence. And it never was. There was never any testimony from either lien holder, the representatives for the lien holders, as to whether or not any particular item was a fixture.
Weren't they represented to be fixtures in the subsequent sale?
I do not believe so, Your Honor.
So they sold items of personal property in the subsequent sale for over $1 million?
Well, yeah, and I don't want to get lost. I want to answer Your Honor's questions. To begin with, it's important to know that all this jury could have known was that items of personal property were removed from the home. Okay? And all my client agreed to doing was buying appliances, which even the state's own witnesses said could have easily been personal property. Now, whether they were put back in and what they were purported to be in the resale really has no bearing, Your Honor, on whether or not my client did something that was reasonably calculated to deceive Bayview. From a common sense standpoint, anything that happened after October 12th, which was the day of the short sale closing, nothing that happened after that could be reasonably calculated to change the nature of the transaction or to paint a false picture for Bayview. And
Is that, I mean, we're talking about a marketplace here.
correct.
And we have a lien piece of paper that is worth something.
Correct.
We have $1.4 million outstanding on that. And the amount of that paper is whatever the market dictates at sale. Isn't that correct?
That is correct, Your Honor.
So how can you argue that 10 weeks difference, doubling a sales price, is irrelevant to the question of whether your client did anything wrong?
The reason I can argue that, Your Honor, is because a short sale really is not a what will the highest offer give to it. And remember, the key point here, my client never said to either lien holder, hey, this is the highest offer we've received. And they never asked that question. We would agree up front that had Bayview asked my client, is this the highest offer, and he lied, we wouldn't even be here. That would be a whole different scenario. All that happened was the owner, Mr. Colson, signed a contract, lofted it up to Bayview, and at that point it was totally Bayview's decision to say, we want to reject this contract, we need more, or we want to own it ourselves, or we want to let it ride and ride the market. Bayview had all the freedom in the world, Your Honors, to make that decision. So a short sale takes it out of what you would normally say is the free market. The other answer to Your Honor's specific question is there was more than one witness at trial. There was a real estate agent and then the closing agent were both asked, have you ever seen a property flip in that short term for that much? And they said, yes, we have seen that before. But the issue for our analysis here legally, forensically, really is, was Bayview being told this is the highest price the market will bear? And they were never told that, and they never asked
There's
that
some
question.
suggestions to that effect.
None.
That seems to me there was a representation that it's unlikely that you can possibly get more than $525 for this property. Your client didn't make any representations along those lines?
I think Your Honor's referring to Exhibit 85, which was the email that got sent to the junior lien holder to First Tennessee Bank. And what he said, and if I may, Your Honor, what he said was, I just spoke with the senior lien holder. I have page 2 of Exhibit 85 in front of me. For the record, it is AG 002998. That is where the specific email comes in. It's dated August 8th. What this email really stands for, this tells us this is the day, August 8th, when Bayview, the senior lien holder, disclosed its bottom line net proceeds. And it wasn't talking about the contract price. Mr. Thornton said to Carissa Wood, who was the contact person at the junior lien holder, I just spoke to the first position lender, Bayview, a few minutes ago. They're pushing me to get their net proceeds of a short sale up over $525. So obviously to get net proceeds, the contract price would have to be much higher than that. And then Mr. Thornton said, which is a stretch from where we are today, as of August 8th, none of the other offers were still on the table. We don't know if any of those offers would have panned out or if they would have found a reason.
Let me ask you, if there had been an offer for $900,000 in cash, they show up with a briefcase in hand that has $900,000. Did your client have any obligation to disclose that to the lender?
Unless, not by statute.
I agree. There's no statute.
And unless the lender came, which the experts at trial testified, sometimes banks would do that in short sales. We will only approve this if both the owner and his agent sign off and confirm and stipulate, stay under oath, this is the highest offer. Neither lender ever presented that type of contract or asked that question ever. So absent that, there's no statutory, contractual, or fiduciary duty to disclose what that offer might be.
So if you look at 13201,
Correct.
right, you point at the omission, and you say an omission isn't criminal unless there's a concomitant duty, an accompanying duty.
Correct.
Right. What about the first part of that? That's disjunctive. What about the voluntary act? Does that require a duty?
The voluntary act does not
So you can do one of two things. You can either, to violate the law, you can
Correct.
have a voluntary act or an omission.
Correct.
Your argument is that the omission comes with a duty. The voluntary act doesn't, does it?
Correct.
Okay. So to the extent your client is charged or the jury concluded your client engaged in a voluntary action, your duty argument misses the mark.
And I would agree. If all the jury did was voluntary acts, the problem with that, Your Honor.
How do we know that the jury didn't just seize upon voluntary acts here? Did the verdict say, we find that the criminal action was not disclosing 11 bids above asking price and JK shares?
No, it did not. It was not a specific verdict. We have no idea. All we know from their mindset, Your Honors, is based on the jury questions that we have. None of the jurors hung around to talk to us. We don't know what was in their mindset.
So what's your authority for us to interpret the jury verdict as premised, as teetering exclusively on an omission rather than a voluntary act?
And, Your Honor, we're not taking the position it teetered on just the omission. We just want to get that out of the way and say there is no way that there was a duty, therefore you can't even consider the failure to report or the failure to disclose the other offers. Then when you look at all the possible voluntary acts, and the Hawes and Proctor cases set out that those acts have to, and it's an objective standard, it's not subjective. It has to be reasonably calculated to deceive. And if Your Honors look at everything that the state alleged could have happened to deceive Bayview, happened before August 8th. And yet we know Bayview wasn't deceived because they said that $525 purchase contract price, we're rejecting that. We want more. They didn't say how much more. They said we'd like our net proceeds to be about here. So from that, everything that happened pre-August 8th, not only was it not reasonably calculated to deceive Bayview, it had zero effect on Bayview.
Well, let's talk about before then, the voluntary acts. What about an MLS statement that has like 33 words and is a cautionary tale about, if you buy this, it's all uphill. Your client crafted that, didn't he? That's a voluntary act. Didn't he craft an MLS that had substantially less square footage and omitted all sorts of material points from the description of what was for sale? Are those voluntary acts?
To begin with, my client testified he put in what his client told him to put in, the owner. And so, yes, it was a voluntary act for him or a staff member to sit down and punch it into MLS. But there is no testimony that either lien holder ever looked at MLS. And, Your Honor, if I may,
what does that have to do with us assessing a voluntary act?
Well,
is there something in the statute that requires them to have looked at?
No, but it has to be an involuntary act that was intended to deceive. And, Your Honor, the testimony was clear. There is no definition of bedroom. Even the two professional appraisers could not agree on the number of bedrooms and the number of square footage. One included the mother-in-law cottage, the casita, one didn't. So if you look at the two appraisals, and it's set out on the chart in our brief, the two appraisers couldn't get the same information. So you have to have a voluntary act, has to be a misstatement of fact. And if there's no definition of bedroom, and the professionals can't get it right, Your Honor.
Couldn't the jurors reach a contrary conclusion just saying we can look at this overall listing initially and see that it understates the value of the property?
But then I would direct Your Honors back to the Hawes decision. How is that then intended to deceive the lien holders who never saw it, never cared about it? It really comes down to Exhibit 77, which was Bayview's scenario results summary.
Who never saw what?
The MLS listing.
But they cared about how much money they got.
Correct. But they had all the freedom in the world to reject the contract, which they did. They rejected the first one, and there was nothing that forced them to give their bottom line net proceeds number. They did that of their own volition. They lofted that number out and said, here's what we would like to get. You guys figure out what you want to do.
So your point is these are rational economic actors, and this lender should have done due diligence, and its failure to do due diligence has consequences.
Correct. It's a multi-billion-dollar corporation who had the ability to look out for its own financial self-interest, and there was no fraud. There were no false statements perpetrated or directed toward either lien holder.
But a jury could conclude that there were false statements directed towards potential purchasers of the property, and having a lower purchase price would effectively defraud the creditors.
You made two statements there. The jury could have concluded that there were false statements toward the buyers,
right,
potential buyers. Since they got to go through and look at the property, I'm not sure that a reasonable jury could conclude that. But even if they did, remember, this is a short sale. And remember the issue for the lien holders, they never asked, tell us all the offers so we can pick one and talk to them. They said, give us a contract, and then they rejected that first contract.
Isn't that implicit? If I gotta go back to my initial question, there's a briefcase with $900,000 that somebody has. You're saying that would not be fraudulent conduct on the part of your client if there was cash in hand that would have made the lien holders not whole, but certainly would have paid off more of their lien, and he would have no obligation to disclose that to the lien holders and just say, no, I've decided to sell it to my parents for half that amount.
That's correct. No obligation to disclose it, and
you're saying no obligation to. I mean, your briefing says there's no absolute duty to actively assist the lien holders in maximizing, but there's a difference. Okay, not actively assisting them, but there's a difference between leading them to believe that this is the most that they're going to get. That seems to be a different argument.
Correct, but you can't make the assumption that every offer is going to close. And
but why couldn't the jury? Like I say, I go back to my argument where they're in person with a briefcase with $900,000. We're ready to close right now.
Correct.
And couldn't the jury reach the conclusion that this offer from these people who had $425,000 and said we have other assets that we can have liquidated immediately and the money will be there? Couldn't they essentially reach the same conclusion as if it had been a briefcase with $900,000 ready to close on that date?
They could, but just because that might be an ethical issue, like the jury asked in question 3A, doesn't mean it violates the theft or the fraud statute, Your Honor. The fraud statutes demand more.
And you're saying the fraud, there has to be an affirmative duty?
No, I'm saying there has to be the Hawes statute, the Hawes case, emphasize there has to be conduct on an objective standard that is reasonably calculated to defraud, to change the nature of the transaction. By Mr. Thornton not disclosing that, hey, there are all these other offers, and those offers are speculative, even if they're cash offers, because we never know what an inspection might show, what someone might do after they're now dickering with the bank because a contract's been accepted.
So let's seize on that standard, reasonably calculated. So we're asking ourselves whether a jury, based on this record, could find that there were, let's say, voluntary acts reasonably calculated. And so we take two MLS listings, and one of the MLS listings has 35 words and says buyer must be patient, repairs are needed, needs to be restored. And the second one has 113 words, and it characterizes now it's a vacation retreat luxury home, a magnificent, meticulously move-in ready for the discriminating buyer, on and on. And so if we look at that's in the record.
Correct.
Could a reasonable jury find that there was any intent to deceive here?
Well, the problem is a principal of J.K. Shares never testified. So we don't know how much time, effort, and money J.K. Shares put into renovating the property. That is not in the record. So without that information in the record, Your Honor, the answer to the question is no. It would be improper speculation for the jury to guess as to whether or not J.K. Shares put any...
But wasn't your client asked if there had been substantial repairs done to the property, and he indicated that there were not?
But he also did say that he was not the principal and that, you know, you would have to speak to his father, who had invoked his Fifth Amendment right, because he was under consideration being investigated as well. Your Honors, I have 1 minute left. With your permission, I would like to reserve that for rebuttal.
Thank you.
Good morning. Assistant Attorney General Michael O'Toole on behalf of the state. I know opposing counsel thinks this is a case of first impression. I think he's going to encourage the court to issue an opinion in this case, but the state is going to encourage the court not to issue an opinion in this case, and here's why. This case is really a mess below. At the settling of the instructions, the trial court decided to give a definition of omission from the general definitions from the Raji's, which track the general definitions in the criminal statutes. And one of those definitions, omission, is basically encompasses the second part of 13201. And then there's also a definition for voluntary act in the same general definitional sections. But the prelude to those definitions say, unless the context otherwise requires. Here, the fraud statute otherwise requires not to include that definition of omission. That is because when we have the statutory concept of no criminal liability without for an omission without a duty imposed by law, we're basically presupposing non-action. The fraud statute, in turn, presupposes action, making something happen. Here, the defendant is not sitting on the couch doing nothing. He's being part of this short sale. He's doing something. So he's defrauding someone by one of three means, and one of those means is making material omission. So it's simply that definition of omission in the general statute does not apply here. And the defendant got a big break here because they were instructed that it applied. So this case went to the jury, basically imposing this additional requirement that simply does not exist. Nonetheless, based on that, and the prosecutors below did not object, so we have this kind of beneficial instruction for the defendant, and based on that, the jurors were really here required to basically find affirmative actions by the defendant, and there was plenty of affirmative actions by the defendant.
Counsel, do you have any authority for that exceptional, was it unless other circumstances require? Is that, do you have any common law authority or legislative history to support the fact that that means no duty is required when you are bringing criminal charges based on certain omissions?
Well, I think 13201, as Your Honor was asking about, basically allows two bases for criminal liability. Generally, we have the voluntary act. Here we have the voluntary act. So that's consistent with the fraud statute, and we shouldn't go backwards and impose this non-duty type of thing, or omission type of liability. Omission, something like that would apply if you had, for example, a child in the middle of the road, and there's one house over here who does not have any relation to the child in the middle of the street. Then you have the mother on the other side. Well, the person with no duty has no responsibility, but the mother has a duty. So in that circumstance, that would be an appropriate instruction. When you have someone engaging in a voluntary act, agreeing to sell this house for his friend, and involved in this entire transaction, it's inconsistent with Haas, first of all, to basically slice and dice and try to basically ask whether this is an omission or a half-truth or a voluntary act. He's basically engaging with the bank, and that's a voluntary act on his part.
So your point is that the statute captures a narrative, and so here we have a basket of voluntary acts and some omissions, all of which make up a single criminal enterprise or criminal act. And so this statute, when it has the disjunctive or, is talking about a singular criminal act that is only an omission rather than a sort of enterprise that is sprinkled with acts and omissions.
Exactly. But the case did go to the jury this way, and that's why it's kind of a confusing case. The state's brief was already oversized. We could have made this preliminary argument, but this is the case, the way the case went to the jury, erroneously to his benefit, and there's still plenty of evidence about to support his conviction for fraud. Notably, the evidence of the omission still comes into trial, even if he does not serve as a basis for criminal liability. That's relevant to the stretch email, basically showing that the jurors could find that was an act of misrepresentation. It goes to his intent in the first place to show that he wasn't really acting on behalf of his friend to sell this property as quickly as possible. If that was the case, he would have taken that first cash offer, or at least given it to his client. He didn't before it ran out. If he was really acting on behalf of Mr. Colson, trying to get rid of the house as quick as possible, he would have considered one of those two high offers, which the banks would have jumped at. The one was for $707,000 cash. There's also, as the court pointed out, the drastic difference in the two listings. The first one's missing a casita, a house, a little house, a whole house, not in the listing at all. You have the fact that he's actively representing himself as a realtor who's willing to listen to all bids for this house, and in fact, from the very get-go, he was going to only accept one offer, his parents' offer.
Let me ask you, counsel. Go ahead.
I'll ask.
Have you come across, either in your experience or in the common law, Westlaw, any instance in which a real estate agent in a short sale is charged with theft? Rather than bank fraud or fraudulent schemes, theft?
No.
And could I ask why the conduct underlying the theft conviction is the same conduct underlying the fraudulent schemes conviction? So is there a basis for imposing consecutive sentences?
Well, the trial court gave the defendant a choice between 3 years concurrent on each sentence, or 3 years on count one, followed by 6 months probation on count two. So he chose the second one for his own reason after consultation with counsel. So at this point, that issue is basically an invited error if there's a 13-116 error.
Doesn't it result in an illegal sentence if it's...
Don't we have a duty, if it's an illegal sentence, to overturn it?
Well,
send it back for a resentencing?
Under these circumstances, when he made that choice, I don't think so, and that issue has not been addressed on appeal, so I think it's abandoned, waived on appeal. But
it's a waivable argument?
You can waive anything on appeal by not addressing it in a brief. According to Supreme Court in State versus Carver, we need significant arguments about issues. The courts can sometimes address those issues, but here it's something the defendant wanted, apparently for whatever reason. He maybe was hoping that one conviction would be overturned and he'd just have his probation sentence. I can't really speculate about that, but this really seems to be a clear case of invited error. It's not a double jeopardy violation, so it's something that I think it is waivable by the defendant. I'd like to address a few points made by counsel during his presentation. Number one, he seems to indicate that his client had to actively make misrepresentations to Bayview itself, but in fact the statute does not require that. Regardless of who he makes those misrepresentations to, that it can serve as a basis for fraud. So he's making them all along the way to the general public, to the two high bidders, basically trying to dissuade them from looking into this matter and maybe contacting the banks themselves. We know later on these people were interested in this sale, so he had to try to keep them at bay. Counsel also said that there was no proof that these fixtures were secured by the security interest. Well, it would have been preferable, I suppose, if we would have had the lien documents in the record, but just because DNA is the best evidence of identity doesn't mean that's the only way to prove identity. And there was abundance of evidence here, including evidence by the Bayview representative that these were part of the property that was secured by the liens here. Opposing counsel also referred to Exhibit 77, which was Bayview's kind of matrix of what to do here, and says, well, this shows what they're going to do anyway, so we can't really say that the actions of the defendant caused this. But that matrix included the appraisal that was conducted after the defendant removed the fixtures, depreciated the property, and kind of massaged the appraiser and gave him a bunch of information, including a possible code violation and all kinds of problems with the property to undervalue the property.
Counsel, what about the due diligence argument? That this is a rational economic actor, in fact, a substantial financial institution that apparently did not or did nothing to protect their own pecuniary interest. Is that relevant at all?
No, if a home was burgled, you can say, well, the victim could have had a lock on his door, and he didn't, and it doesn't mean it's his fault. So here, the bank was a victim. They assumed the defendant was acting in good faith. That was a bad assumption on their part, but it doesn't relieve them of criminal liability. And finally, opposing counsel says we don't really know how much J.K. shares the defendant's father put into the home before he resold it, but the only fair inference is this closes in, I think, October and resells in December. We had the Pertels going back and saying nothing really changed in the place. We have a disclosure basically indicating that no substantial property improvements were made. The only thing that was in the record as far as improvements go, other than the fixtures being replaced, was the fact that there's a termite inspection for $650. Finally, he basically, opposing counsel also said there's no proof that his client removed the fixtures, but in fact Keith Colson would be the only other person who could have done it. He said he removed some theater equipment, and that was it. Everything else was there. So the only inference from that is that the defendant removed that property. Unless the court has other questions, I ask the court to affirm the convictions. Thank you.
Your Honors, I'll be quick in 1 minute. We talked about Rule 20 in my first 19. I want to emphasize my other issues on appeal. And the Proctor case specifically, pinpoint site 564, says whether a defendant had a civil duty to disclose material information may be relevant evidence as to his or her state of mind. And in Proctor, the trial court agreed. And the trial court in Proctor let the real estate agent talk about those. Mr. Thornton was prevented from doing that. Because of that, the burden of proof shifted. Instead of being presumed innocent, that all he did was the normal course of a real estate short sale, suddenly he was presumed guilty. And then later in Proctor, the next paragraph, it says, whether one can be prosecuted under the statute solely for failing to disclose material information, whether that's a voluntary act or not, the Proctor case didn't reach. That's the case we have here. Nothing that my client said or did defrauded Bayview. Thank you, Your Honors. My time is up.
Thank you. Thank you very much for your arguments today. We will get a decision out in the ordinary course.